Good afternoon, everybody, and welcome to this webinar about the new LBTT online system. I'm Isabel D'Inverno from Brodie's. I'm head of corporate tax here, and my tax colleague Bob Langridge will be joining in shortly. Hello, Bob.
Hello.
So the new SETS system, as hopefully people will know, is expected to go live on Wednesday, the 24th of June. And we wanted to tell you a little about the new system, how to deal with the downtime, and also to make you aware of some recent penalty cases, which are actually really important. And as you'll hear later on, could be of significance to many of you. So moving on to SETS2, here are some slides which Revenue Scotland have actually provided. And they explain, first of all, that there'll be a period of downtime between the 18th of July and the 24th of July. And during that period, the system will actually be shut, so you will not be able to submit an online LBTT return. During that period, all the draft returns and all the already submitted returns will be transferred across to the new system. And we have every expectation that that will all happen seamlessly. However, it's important to just be aware of what's going on in the background so that you can be in the best possible place to deal with all of this. When the new system switches on, you'll be asked to accept new terms and conditions to use it, and the terms and conditions are fine, so just accept them. You'll also have to make a new password, which is a bit of a pain in the neck. They are quite difficult to make, aren't they? But that will be a small price to pay, because the new system is actually quite good. Well, the old system is quite good, as I'm sure people will agree, but the new system has a lot of improvements. There'll be a better dashboard which will show all the returns that are in progress and the ones that have been submitted, and will also show whether the tax has been paid. And that's really important and helpful, because I'm sure everybody has situations where, although the return's been submitted for one reason or another, the tax isn't actually paid, and that can lead to a penalty. So the online dashboard will also show you electronic messages, the secure messaging system, which is being enhanced. That's a picture of the dashboard, which is probably a bit difficult to see, but it gives you an idea of how useful it will probably be. The online secure messaging system is another enhancement. It exists at the minute, but at the moment when you send a secure message into Revenue Scotland, it just goes into a big bucket. It's not tied up with the return. And the new system, the secure messaging, will be tied up with the return. So that will be quite helpful to send in, for example, a computation of multiple dwellings relief, or an explanation of what's been done where there are lots of transactions included in one return, or whatever it is, and you want to send a schedule. Of course, it will be essential to keep a copy of any secure message that you send to Revenue Scotland in your online document management system, or your paper file, or whatever it is that you use. You shouldn't just be relying on it being in Revenue Scotland's archives. But all of these things are helpful improvements. All the LBTT returns can be found in one place. To be honest, I'm not quite sure what that will mean, but we'll see when the new system opens. And they have taken on board a lot of comments that we've certainly made about making the system easier to navigate and whatnot. So the go-live date and the shutdown date have now been confirmed by Revenue Scotland, and we can be sure that it will shut down on the 18th at 4 p.m. So one of the validation things that's going to be introduced in the new system is postcode validation. At the moment, the postcode doesn't have to tie up with the local authority number, and that's caused a lot of returns to go in with effectively the wrong local authority number. The new system will validate that. It'll check the postcode against the local authority number. It doesn't matter if you don't have a postcode, you'll still be able to submit a return, but there will be this added level of validation, and there's validation in a few other areas as well. However, they have said that it won't be a problem if you don't have a postcode for a new return, but also if you don't have a postcode for an old return, because this kind of validation, or if your postcode doesn't match for that matter, because this validation thing will be switched off for existing returns. But that's an area where if you have a problem, then just get in touch with Revenue Scotland. So phase 2 of SETS will introduce other things, changes to allow taxpayers to submit 3 yearly returns electronically, and also so that taxpayers can do ADS repayment claims electronically. And it will be an iterative process of more and more enhancements being made to the online system, which is a good thing, and it's helpful that Revenue Scotland appreciate the requirement for that. I'll hand over to Bob now to explain what to do during the downtime, or how to manage the downtime. Bob.
Hi. So there will be approximately 6 days of downtime between old sets switching off and new sets switching on Wednesday the 24th. In that period, it is not going to be possible to submit any returns online whatsoever. And therefore, you really do have two choices. In our view, the single best thing that can be done is, wherever possible, ensure, particularly if it's a large or complex transaction where registration is going to be important, that returns are submitted before Thursday, 18th of July, wherever possible. One thing a few people don't realise about the SET system as currently stands is that, unlike, say, SDLT, it's possible to submit returns early, i.e. before the effective date. So even if you have something completing in the downtime, if you're reasonably confident in the LBTT position and you are in funds, you can always submit that return early. As a general rule of thumb, again, it'd be better to try and avoid having in-progress returns during the downtime, so drafts sitting in the system. Even though these are supposed to be transferred across, this is, after all, a government IT project, so there could be unknowable difficulties.
Oh, ye of little faith.
And it will be better, perhaps, just to start new returns if you encounter them. Revenue Scotland is going to have an increased team to deal with issues arising from the switchover during this period, and Registers of Scotland have helpfully said that they won't bounce registrations that come in during the downtime just because no return has been submitted. Now, if you find yourself in the position where you cannot submit an online return in advance, but you want to submit a return during the downtime, for example, to hedge against a penalty arising, then Revenue Scotland will be accepting paper returns. There are new paper returns that will be introduced to match SETS2, but the existing paper returns, which can be downloaded from Revenue Scotland's website, can be used up until the 24th. There are 5 kinds of paper returns that are available. 2 for general purchases, the standard return plus additional information sheets. There is a separate return for the additional dwelling supplement, should you need to report on that. Then there is a lease review return, which is a separate document, as well as an additional information sheet if you are acting for the outgoing assignor and doing an assignation return. It says on our slide, rather perhaps optimistically as a shameless plug, that these can be signed by Brodies as agent. They can in fact be signed by anyone who's acting as the agent. So you do not need to have your client signing those forms before they can be submitted, provided they have authorized them in the usual way.
And you don't, as a point of detail, you don't need one of the agent authorization forms either. You know, you can just sign as agent without an authorization form. That
is correct, because the return itself contains the necessary confirmation that you have authorization. And just another practical point to note is that, unlike in the past, these returns have to be delivered to Revenue Scotland and not Registers of Scotland. And bearing in mind arrangement satisfactory. If you are sending a paper return, the only way you can make payment within the arrangement satisfactory rules is by including a check with the return itself. The downside of doing a paper return during this time is that Revenue Scotland will not actually process the return until the new system goes up on the 24th. That means that the details will be inputted into the system, and Registers of Scotland will not have sight of whether a return has been submitted till that point. The knock-on implication of this is that even the Registers of Scotland won't bounce applications because they have a statutory duty only to accept applications where, if LBTT returns are required, they have been submitted. They won't be able to progress registrations for which paper returns have been submitted until after the 24th.
So they're going to kind of pause the process at the checking the return thing. Revenue Scotland will be keeping a list of all the submitted returns, and if necessary, registers, or as soon as the system goes live, registers will be mindful of what's on the list. And if people have concerns about whether something's been received by Revenue Scotland in terms of the paper return, you can phone them and ask. So that may be necessary. But sorry, Bob, carry on.
Another practical point to be wary of with paper returns, and this is particularly relevant if you've got purchases where there is third-party lending and there are conditions precedent and undertakings in the facility agreements, are that we won't be getting, or you won't be getting, automatic receipts for a paper return. Instead, they will be issued by post, and they will be issued after the 24th. So there won't be any immediate evidence to hand that a return has been submitted. So if you do have, for example, a facility agreement with an undertaking to deliver the SDLT5 equivalent from Revenue Scotland, do be careful as to how those are worded to make sure you're not setting yourself up with an unmeetable obligation.
But everybody will be in the same boat. It's just that cross-border transactions or accountants or whatever will not necessarily be aware of it.
So, the next half of this webinar is going to cover penalty cases, the Revenue Scotland penalties, and also dealing with penalties as and when they arise. So I'm going to hand back to Isabel to talk through the two main classes of penalties that Revenue Scotland charge.
So the penalties are much harsher than was the position for SDLT, where it was pretty much just a question of a £100 penalty, wasn't it? For LBTT, we have not only late filing penalties, but also late payment penalties. The late filing penalties, it's £100 if you're 1 day late. Once you get to 3 months late, it's £10 a day for 90 days. And there's a question mark above the daily penalties, and that's because they've been thrown under question by the tribunal cases, which we'll come on to. Once you get to 6 months late, it's 5% of the unpaid tax, and 12 months late, it's 5% of the unpaid tax, and that's all cumulative. So they can add up to being quite chunky. When you include the late payment penalties as well, you can get up to quite significant figures. We've seen penalties of £20,000 and things like that.
Over £60,000 is
over £60,000 is the highest, yeah, that we've seen, and which somebody has actually paid. The late payment penalties obviously only apply if there is LBTT payable, although Revenue Scotland do sometimes charge them by accident, and it's always worth carefully checking what a penalty notice says, by the way, rather than just accepting that it will be correct. So the late payment penalties, you have 30 days broadly to pay the tax after the filing date. Once you get past that date, if you're 1 day late, then the penalty is 5% of the tax. Once you're 6 months after when it should have been paid, it's a further 5%, and then a further 5% again after 12 months. Obviously, there are much higher penalties if you've been really wicked and you've just falsified the return and all the rest of it, but we're not talking about that situation here, more just the situations which often occur where clients don't realise that they need to do a return at all, or the return's been submitted but the tax for some reason wasn't paid or whatever it is along those lines. But these late payment penalties are cumulative and they're on top of the late filing penalties, as we've mentioned. The late filing penalties apply whether there's tax or not, and the maximum that Revenue Scotland can actually charge is £1,600, but that is quite a lot for a return where there's no tax. However, there may be a get-out-of-jail-free card, but it doesn't work in the way that you might think, so Bob will explain.
So, there is a statutory get-out-of-jail-free card, as Isabel mentioned, and that is having a reasonable excuse. Now, the penalties legislation recognises, and this is common across a lot of taxes regimes, that if there is a reasonable excuse for whatever the breach that led to a penalty, be it late payment or late filing, then a penalty can be overturned. However, I think what a lot of solicitors fail to recognise, and we see this a lot when we are acting, particularly in penalty disputes for other firms, is that it's the taxpayer's reasonable excuse that counts, and not the agent's. What we tend to see when we are dealing with penalty cases are agents writing to Revenue Scotland saying, "We apologise for this late payment, this was an administrative error on our part, it won't happen again, please will you reconsider?" And in the eyes of Revenue Scotland, that is meaningless because it has nothing to do with the taxpayer's own position. And what the legislation actually provides for is that you can have a reasonable excuse if you rely on a third party, such as a lawyer, to complete the LBTT return, but in order to have a reasonable excuse, the taxpayer has to have taken reasonable care. Because this is something that's common across a number of different tax regimes, there's quite a lot of jurisprudence around reasonable excuse and reasonable care, but generally the courts have held that a client simply being passive does not pass the reasonable care bar unless they have a reason for not following up with you. The other thing that it's important to know about trying to make a reasonable excuse argument is that you only really have 3 chances to overturn a penalty notice once it has been issued. The first opportunity is giving an initial response to a penalty notice. If you give an initial response, Revenue Scotland will issue something called an appealable decision. And that appealable decision can only be addressed in 2 ways: by requesting an internal review or by making an appeal to the tax tribunals, which is a public appeal. At the first step, you can choose between an internal review or going straight to the tribunal. If you go for an internal review, Revenue Scotland has 30 days for another tax officer to review the papers and issue their own view of the matter. If they upheld the original decision, then your only recourse is then to take things to tribunal. Unfortunately, and this is a real danger area when responding to penalty notices, we do frequently see solicitors who have made the "I'm sorry, this was our fault" argument to Revenue Scotland, then repeating that, and in Revenue Scotland's eyes, that solicitor has then requested the internal review process.
Yeah, so if you say, "Please reconsider," Revenue Scotland think that you're asking them for an internal review.
And what that means is that because no relevant arguments have actually been raised about whether a penalty is chargeable, the only recourse at that point is to lead a tribunal appeal, which may or may not be in the client's best interests because it is a public appeal. And of course it may or may not be in your best interests.
So the reasonable excuse thing is something that we have seen a lot. So bear in mind that it's the taxpayer's reasonable excuse, not your reasonable excuse. And bear in mind that you've got to be careful what you say to Revenue Scotland in case they take it as you asking for an internal review. The final thing we wanted to mention were some important penalties cases which have just happened. It's probably very sad to be as excited about penalties cases as Bob and I are, But
there's no probably.
Okay, so we're very excited by this. But what has actually happened is that the Scottish Tax Tribunal has cancelled the daily penalties for a couple of taxpayers who appealed against them. And the £10 a day for 90 days penalties have been quashed by not just the first tier tribunal, but also on appeal by the upper tribunal. So that's quite a thing. These decisions are relatively recent. If you want to look at them, we've given the links to the tribunal websites where they are published. But we are currently waiting to see whether the upper tribunal actually, whether the upper tribunal decision is appealed against by Revenue Scotland. Revenue Scotland are thinking about whether they want to appeal. If they don't appeal, then we'll be in a position where the courts have held, or the tribunal has held, that the daily penalties are not properly chargeable. And we think that what Revenue Scotland should do then is repay them all. So any taxpayer who has incurred such a penalty should get their money back. We're not quite at that stage yet because we don't know whether Revenue Scotland are going to appeal. So I guess the message is a bit of a watch this space. But in the meantime, if you receive a penalty notice which has got the daily penalties in it, I would probably think twice about paying it just now because it isn't absolutely clear that the penalties are properly chargeable.
And the other thing to be mindful of is these two cases involve quite heavy and detailed discussion of the procedural requirements for these penalties to be charged. It may be possible that with future penalties, Revenue Scotland are able to adopt a procedure that works so that they are valid. But if they don't appeal this case, and if there is no retrospective legislation fixing the issue, it could very well mean that historical penalties that have included the daily penalties of up to £900 have not been properly charged and are refundable. So it's worth having a look back through your files, noting which clients have been subject to these penalties, because they could very well have a claim for up to £900 plus interest on their hands.
Which would be a nice outcome to what would otherwise have been a sorry story for them. So we hope that you found this webinar helpful. We will be sending out a follow-up email afterwards with a copy or a link to a recording of the webinar if you want to run back over any aspects of it. We also will be happy to answer any questions. We should have said at the beginning that there was a question box for you to ask questions in, but it's a bit late now, to be honest. So if you do have any questions, please send us an email. Our email addresses are on the slides, and we'll be happy to answer any of these questions. Revenue Scotland will be updating the FAQs on their website at the beginning of next week, we understand. But hopefully we've passed on all of the key messages about the change. And as I say, please do get in touch if we can help at any time over this changeover period. Thanks very much for tuning in, and we hope to see you on our next webinar.
Bye.